Justice and dispute resolution. How will the new claims procedure help in this endeavor? The judiciary is carrying out internal reforms aimed at improving service delivery and ensuring that Ugandans get justice as soon as possible. In the recent past, the judiciary has reported challenges, including a huge case backlog, lack of enough staff, including magistrates and judges, challenges that have impacted negatively on its operations. Currently, courts remain the most favored centers for conflict resolution, even in situations where matters would have been resolved out of court. The judiciary has now introduced a small claims procedure to handle disputes of a certain magnitude, but some lawyers are unhappy about this new procedure, since the complainant does not have to acquire legal services in pursuit of justice. It is this process that we analyze today on Spectrum to try and understand how you can use it to settle a dispute and how this will help the judiciary in delivering justice faster. During this discussion, we'll also look at other challenges that the judiciary faces today and also put forward the concerns you members of the public have running about the judiciary. Our guest tonight, Mr. Araali Muhiirwa, Araali Muhiirwa, Grade 1 Magistrate at Buganda Road, also Assistant Public Relations Officer of the Judiciary. You're most welcome, Mr. Muhiirwa.
Sancho.
Tell us, what are small claims?
First of all, I wish to bring greetings from the judiciary to the people of Uganda.
Friendly greetings.
Yes, please. Secondly, I would like to inform the citizens that the judiciary is mandated under Article 126 to adjudicate all disputes between people and the state, then between the state and the citizens, then between citizens and citizens. So that mandate must be executed by the judiciary through the courts of law. Now, these courts of law, as established, are of different levels. If you can start with the highest court in the country, we have the Supreme Court. Then below it, we have the Court of Appeal. We have the High Court. We have Chief Magistrates Courts. Now, the Chief Magistrates Courts are of 3 levels. The Chief Magistrates Court itself, the court presided over by Magistrates Grade 1, and courts presided over by Magistrates Grade 2. So, all those courts, right from below, Magistrates Grade 2 to Supreme Court, are what we call courts of judicature. And in executing their mandate, the major role on top of resolving disputes is to promote the rule of law, to interpret the Constitution and other laws made by Parliament, and protect human rights. So, through that mandate, we keep doing research on how our courts operate. Sometime back, we did research and found out that disputes of commercial nature needed top priority. And as such, we had to establish a commercial court as a division of High Court. The commercial court has been very successful, although it has still a lot of cases. However, we did more research and found out that in the magistrates' courts, there are also disputes of commercial nature. Therefore, we decided to create a procedure that will be quick, fast track, as a new innovation to handle those type of cases. Now, today, I come here to explain to the citizens of Uganda this new small claims procedure. What is it, what it entails, the procedure itself, where it will operate, and how it will operate. The small claims procedure, after doing that research, we decided as the judiciary to pilot it out in the country. And we are going to pilot it out at Mengo Chief Magistrates Court, that is for Kampala, Masaka Chief Magistrates Court for Masaka Region, Kabale, Arua, Mbale, Lira and Lira and Arua. Those 6 magistrates courts will work as a pilot for the small claims procedure. Now that brings me to a question: what is a small claims procedure, or what is a small claims court? A small claims court is that court which will be presided over by a judge, a chief magistrate, or a magistrate grade 1. But what type of claim can be filed in such a court? It should be a claim of a commercial nature which does not exceed 10 million. Any claim above 10 million will be filed in the normal courts, in the normal way, in the normal procedure. Now, this procedure is a new innovation. I want to emphasize that it is a new innovation which is intended to promote access to justice, especially for that group of people who have disputes of commercial nature between 1 shilling to 10 million. It will also provide an easy and simple method of filing of such a claim. And the adjudication method is quick, non-adversarial. And now we are departing away from the adversarial method, where the litigants are subjected to strict cross-examination. In this procedure, there will be no strict cross-examination. I will further simplify it in this way, that this method, we shall remain with the old method, the current method of filing cases. For instance, we can call it, that's window 1. Now, we are creating window 2 to address this type of disputes, but which don't exceed 10 million. Which are these disputes? It could be debts of commercial nature. It could be claim for rent recovery. I'll give you examples. For instance, if Okero sold his second-hand car to Mukasa, and they agreed that the second-hand car is 7 million. Mukasa pays 2 million. He remains with 5 million. Now, that 5 million, if Mukasa doesn't pay Okero, falls under the category of a small claims procedure, a small claims dispute. It can therefore be paid under that procedure in a small claims court, because it is between 1 shilling and 10 million. Now, what is unique with this procedure? The uniqueness of this procedure is that before filing a claim, you can notify the other party by giving him a warning verbally. Like we are here, say, Mr. Mukasa or Mr. Okero, if you don't pay me, I will take you to a small claims court. That is sufficient notice. You can do it in writing. You write to him a letter, say, you remember I sold you my car, you remain with a balance of 5 million, it is due, can you pay? If you don't pay, I take you to a small claims court. You can do it on phone. All these procedures I'm explaining in the other main procedure may not be allowed. Although you may notify somebody in writing that I'm going to take you to court.
Right.
But now we are adding that it can be verbal. You can also use telephone communication. Now, having communicated to the other party, you have now a right, if he does not comply by paying you, to go to the small claims court and ask for an ordinary form in the form of a demand notice. It is a form simplified in simple English, and it's a matter for you to fill it. Say, I'm called Mukasa, I'm suing Okero for a claim of 5 million. I sold him a car on 5th October, 220,000. You sign and put a date, full stop. Now that is a claim, which is not a procedure in the current method we are using. So this one is simplified for these cases of the commercial nature, because we know the more cases delay in courts, the more it impacts on the economy. And this was research clearly made, and we found out that most of the claims of the commercial nature in the magistrate courts fall between 1 shilling to 10 million. But because we have case backlog, we decided now, through consultation with other stakeholders, that we institute the small claims procedure. It is a fast-track system. And this fast-track system has been incidentally tested in the commercial court, although not in this form.
Yes.
Now this one is responding to these complaints that how can a case of 500,000 or 2 million spend in court 3 years or 2 years. So this is a procedure we are bringing forward beginning 1st November.
You've already started with it?
Yes, please. In those courts. The other good thing with this procedure is that the moment you subject yourself to this procedure and the magistrate takes a decision on it, that decision will be final. There will be no right to appeal.
Yes.
So the moment you subject yourself to this procedure,
yes, you cannot appeal against.
You cannot appeal against the decision.
Is that fair?
It is fair, because we are saying we have window 1
and
for the ordinary procedure.
Window 2.
We have window 2,
which is expedited,
where the disputes are straightforward. I showed you a car. The argument is here. You're supposed to pay in 2 months' time. You have not paid. Now these are 4 months down the road. So what are you going to appeal against? And we made a lot of consultations with other stakeholders in the justice sector and Uganda Law Society. And we said, yes, let's carry out this procedure. The other issue which I would like the members of the public to understand is that the magistrates are mandated to hear these cases there and then.
Oh, what do you mean?
What I mean is that the moment the claimant comes to court and gets a demand notice, after the demand notice, the other party does not comply with payment of that debt, he will come and fill a form which will now be a plaint or a claim.
Yes.
It's actually in this language, in this procedure, we call it a claim.
Yes.
Now that claim, it would be served to the other party. Now the other party is free to pay up, and the case is closed there and then, or to file a defense and say, I don't know that claim, or to file a counter claim and say, although I bought a car from you and I have a debt of 5 million, but when you came to Masindi, or when we met in Sheraton, I gave you 500,000, which was supposed to be deducted from the 5 million. Therefore, your claim is no longer 5 million, but 4.5 million.
Yes.
So you can't file that type of counter claim. Now, when you appear in court, the procedure is so simplified that you stand there as the plaintiff. I stand this side as the defendant before the magistrate. But on that day, both of you must come with your documents, if any, receipts, agreements, supporting documents, if any, and you should also come with your witnesses. Then the claimant will give his view. I met this man on Room Street. He sold me his car. I sold him my car. He paid me 2 million. Balance was 5 million. I'm demanding 5 million. Full stop. Then the other party will say, I know the 5 million, but I offset 500,000 when we met in Sheraton.
No legal jargon.
No legal jargon.
My lord this, my
nothing.
lord, article this, article that.
Nothing. The only thing we shall provide in the court is the interpreter, in case the two parties are of different languages. So the magistrate will be the one to ask questions. I said as I was beginning that we are diverting in this procedure from the adversarial system. Now this one is sort of inquisitory. Yeah.
You ask questions.
Yes, it is the magistrate to ask you now. You said you gave him 5 500,000 at Sheraton, was this connected to the date with something, another transaction? So the moment the magistrate is satisfied that the claim is proved, he will give the judgment there and then. So departing from the other system, there will be no cross-examination.
And you have a court clerk to write not down.
It is the magistrate now to write.
Yes.
However, in this same system, the parties are free to say, let's go outside
and agree
and settle this matter, either through mediation, arbitration, or any other alternative dispute resolution. But the magistrate must give not more than 14 days for such a situation to be completed.
Yes.
Because we are saying this is a quick fast track system, and the magistrate is mandated within 30 days to have completed this type of case. The other issue I would like to inform the members of the public that under this system, you are free to have a consent judgment.
Yes.
If you agree, and that consent judgment will be filed as a final judgment.
So you say, I'll pay me 90 days, and you agree before the magistrate.
Yes, but the agreement shouldn't be unreasonable.
Well, if the two of you agree, what's wrong with that?
Because you see, when you agree and you don't settle within time, this case may not.
It cannot come back.
It may come back. So we are saying, when we are telling this magistrate, we are saying the agreement should be reasonable, and so that this matter is settled out and the file closed. However, I said that there would be no appeal. But if no evidence arises within the period of 1 year, you can come for a review.
Yes.
So you're going to ask me, what is the difference between an appeal and a review?
Yes.
An appeal is
to a higher court.
A review is the same court, but on the same matter. Say, the other time the court ordered that they pay 4.5 million. In the actual sense, the other you ordered that they pay 5 million. In the actual sense, the other 500,000 which I was talking about that I paid Okero at Sheraton, the receipt is here. So can this court review this issue so that I pay 4.5 million? This is the 500,000. So those are the new techniques that we are developing in the judiciary. One, to quicken justice for Ugandans, especially in the cases of commercial nature. Two, to make courts accessible. Three, to fight against backlog in the court system. People may even ask another question: when court has made a final judgment, since it is under the small claims procedure, how will it be enforced?
Yes.
Now, when it comes to enforcement, the provisions of this procedure provide that the courts will enforce this type of orders using the formal procedures of enforcement.
Yes.
Which are these ones? We can sell your property, sell and attachment and sale of the property.
Get a court broker.
Yes.
To do that, yes.
We can attach your salary. For instance, if you are a salaried employee, you can attach your salary.
Yes.
We can send you to a civil prison for a period
6 months,
not more than 6 months. So all these options remain with the powers of the magistrate, within the mandate of the magistrate. So don't think that because it is under the small claims procedure, I will dilly around and not pay up. You end up having an enforcement mechanism using now
the main system.
The main system. And we are appealing to Ugandans. One of the challenges that we have had in courts is that Ugandans are fond of doing things informally, and thus causing a lot of disputes. So when we are sensitizing the members of the public in this type of procedures and any other programs that we carry out as a public relations department, we emphasize that Uganda should learn to do their things in a formal manner by writing agreements, by getting official receipts, so that when disputes come up, it becomes easy to prove, and it also becomes easier for the court to adjudicate upon such a matter. But there is this type of informality. So I have brought my potatoes from Kabale. I come to Owino. I just give them to the trader in Owino. We just agree that I'll come back and pick the money after 3 weeks, or send the money on mobile money, mobile system.
Yes.
After 3 weeks, and the man doesn't send the money, and as a result, we get disputes. But we are saying, if this culture of formality, say, okay, I've left you with my 10 bags of Irish potatoes. Please, can you acknowledge here that I've left the 10 bags of potatoes with you, and the balance is 5 million? Simple as that. So that there is where you can start from.
All right. Well, this is Spectrum on Radio 1. We're going for a break. Tonight, the judiciary is taking steps to improve on justice delivery in dispute resolution. They've instituted the small claims procedure, a revolutionary way to do things, starting November the 1st. We're going for a break. We'll be back, so do stay tuned.
Discover the new invigorating taste of Red Vodka Lemon. Red Vodka Lemon. Reinvent the night. Not for sale to persons under 18.
It's the time again to sweat a little for better. It's that moment to unite again and open our hearts to charity. Run for life, run for water, run with your heart, run with your heart, run for life. Register and run the MTN Kampala Marathon on the 25th of November and help take clean water to Bududa. Run with your heart.
MTN, everywhere you go.
Ça va, hello. My name is Kogole Andemina, very serious Congolese tailor. People see me when they want to look good. People leave my shop looking like superstars of TV. But however much I make you look beautiful or even sexy like me, I cannot change the person inside, the real you. Kind of like Uganda Waraji. It has this beautiful look, but inside they have maintained the same old spirit that we know. The same old spirit we have known for many years in a new suit. New look. Oh, you need to try it.
Enjoy the new look Uganda Waraji. The same Ugandan spirit with a new look. Uganda Waraji. Same spirit, new look.
Uganda Waraji.
Excessive consumption of alcohol is harmful to your health. Not for sale to persons under 18 years. Please drink responsibly. Spectrum on Radio 1 FM 90.
Welcome back on Spectrum. Tonight, the judiciary takes steps to improve on service delivery of justice and dispute resolution. How will the new small claims procedure help in this endeavor? Our guest tonight is Mr. Araali Muhiirwa, Grade 1 Magistrate at Uganda Road, also Assistant Public Relations Officer of the Judiciary. You will be able to call in and contribute to this discussion. Mr. Muhiirwa, why are lawyers unhappy with this new revolutionary method of your work?
First of all, I would like to inform the members of the public that before we came up with this procedure, we did a lot of consultations, and the lawyers, or what we call advocates in the country, were consulted widely, and especially through the Uganda Law Society, which has an executive, it has a president, it has an executive, it has the General Assembly. So we consulted, and we agreed that indeed this procedure, it is high time it came on board. So maybe some members, few members may be dissatisfied with this procedure, but we are saying we want to provide the service to an ordinary mwananchi, an ordinary person who has been saying that the judiciary, there is a lot of case backlog in the judiciary, and therefore people are spending a lot of money and time in litigation. So I don't know.
Litigation
When
has actually gone through formal court procedures.
I don't know when the judiciary comes up and say there's this procedure for these small claims which don't go beyond 10 million. Please use it to have your disputes settled in a quicker, faster manner. I don't think that is bad for this country.
So the point is you're ruling out the lawyers.
We are not ruling out the lawyers. Parties are free to consult the lawyers for legal advice.
But when they come,
the lawyers will not come to appear before the small claims procedure. This is not the first law to exclude lawyers from courts. You know, in this country, we have local council courts. Local council court 1, local council court 2, local council court 3 at the sub-county level. The law clearly says no advocate will appear in these courts. And these are courts created by law. This one is also being created by law.
So it's like under that tree.
We are trying to say
very informal.
That we are trying to say let the ordinary person get his dispute out of the way through this simple procedure provided for, which does not entail a lot of expenses. The only expense you are going to find in this procedure is the court fees, which is also provided before.
How much is that? How much
the court fees,
what percentage?
Is provided for under the court fees schedule.
Yes.
I have the schedule here. I'll give specific examples, some examples.
Yes.
For instance, if you had a claim, let's say a claim of 500,000. Now, the claim for 500,000 falls under the schedule number 53. Between 300 and 600,000, you pay court fees of 49,000. As simple as that. But under this procedure, small claims procedure, when you are claiming the other that money, you top up this money.
Right.
In the form is here. The form it provides for it. In the form it says the principal amount
plus court expense.
You see, the principal amount claimed,
yes,
say shillings 5 million.
Court fee.
Court fee for 49,000. Total amount claimed now.
So the other
500,000 plus this.
How about if it's 10 million? How much would you pay?
10 million falls between 9 million and 12 million.
Yes.
And therefore, the court fees is 91,000.
That's still a small amount.
That's a small amount. And let me inform the public. This 91,000, or what we call court fees, is not money that goes to magistrates or to judges or even to the judiciary.
Where does it go?
We are just a collecting agency. And we don't even touch the money. The money, for us, what we do, we use our cashiers. They give you an assessment form, the Uganda Revenue Authority assessment form.
You go to the bank.
You go with it, for instance, for a Kampala area. You go to Diamond Trust, deposit the money there. For you, bring us a receipt from Uganda Revenue Authority, which we shall endorse and put on file. We don't touch that money. And I'm appealing to Ugandans, don't pay cash money at the courts.
But you might want quick justice, so you talk to the magistrate.
No. We don't want that type of thing. Take the money to the Uganda Revenue Authority account on the authorized banks. So, when you are claiming, you top it up and the magistrate will give you judgment.
It doesn't matter. And do you trust your judges?
We trust our judges, we trust our magistrates, we trust our judicial officers. And we instill discipline into any area of judicial officer. I wish to inform the country that the judiciary does not condone corruption. If I can give an example, we have among those prisoners who are in Uzira serving sentence, there are 2 judicial officers. Why? They were arrested, subjected to due process of fair trial, found guilty, convicted, and taken to Uzira.
They broke the 11th commandment.
For us, we read by example.
They broke the 11th commandment, that thou shalt not get caught.
We read by example. So if you think outside there that you are going to joke around with people's money, with people's property, you'll get your due sentence and due punishment.
Mr. Muhiirwa, talk to us about the experience so far. You started it on the 1st of November. You have had about a couple of days now. How's it going?
The response is very positive, and people are calling, they have been calling our offices, the office of the Registrar Planning and Development, to inquire about this procedure. They have been calling me to inquire about this procedure. They have been calling the 6 chief magistrates to inquire about the procedure. What I wish to inform the country is that we have already sent the forms, the legal materials. We have trained the clerks, we have trained the magistrates. These courts, the 6 courts of Mengo, Masaka, Kabale, Mbale, Lira, and Arua are open for this procedure.
Right. That's the pilot.
Yes, please.
How long does the pilot last?
The pilot will depend, but we had planned between 1 to 3 years, but depending on how people react and how implementation goes on, we shall keep evaluating and monitoring and reviewing. Then we can bring the period low, shorten,
bring it forward,
and roll it out of the country.
So give us some experiences of what have you had from
people have started registering cases, and we have asked the chief magistrates to give us preliminary reports by the end of this month. And after the end of this month, of course, we shall come back to the media houses and inform the public of how the whole progress is going on.
But do you have the staff to run this? Because they might imagine
we have the staff. We have the magistrates. We have the magistrates, and we have advised those chief magistrates to identify among those clerks we trained a specific clerk to be in charge of the small claims court and the small claims procedure. And we have put up notices in all those courts. We have displayed these court fees, and I'm very sure that people will be assisted on ground.
And what matters cannot be brought to this court?
Matters that cannot be brought about in this court, all those matters which are beyond 10 million are not within the jurisdiction of this court. Family matters, probate matters, issues to do with enforcement of wills, issues to do with defamation cases, wrongful arrest, all those type of cases will not come before this court.
How about claims against government, compensation?
No, they won't come to against in this court. They go the normal procedure.
And you can bring a case against an individual, a company?
You can bring a case against an individual to individual. You can bring a case against a company.
Yes.
For instance, let me give you an example. Radio 1 could be a company.
Yes.
If it is renting this building,
yes.
If it doesn't own this building,
yes.
And the landlord is claiming rent, which is up to 10 million, the landlord is free to sue,
to come to you
under the small claims court,
yes,
to sue for recovery of rent. But for you as a company, you cannot sue the individual.
Oh,
yes, you can sue the individual under the
normal court process.
Normal court process. But here, the individual can sue you to recover rent. If a company asked some gentleman already to supply some food here at lunchtime on a certain function,
and they don't deliver,
and they deliver the food and you don't pay the 2 million,
the person can sue you.
Yes,
but you can't. If the person takes the money and doesn't deliver the food,
you don't sue her in this procedure. You sue her under the other normal procedure, which I called window 1, the ordinary one, the normal one.
Yes. When you talk about window 1, window 2, we saw it during the 80s. Foreign exchange was very.
I think the younger people may not understand that term, but the older people may understand it.
You have to buy foreign exchange. You have to go through Bank of Uganda and apply. These days,
what we are saying that the normal court procedure has remained. We are not changing anything, but we are putting in place a simple fast-track system for these specified cases which I have informed you about: debts, recovery of rent, supply of goods. so that people find it easy to recover those type of monies.
Suppose I find it easy, like you say, to recover money using this court, and someone owes me 16 million. Can I bring a case saying 10 million? I recover that, then I bring him back until the 16 is paid.
No, the principles of law do not allow that, because now you are trying to subdivide your debt into different compartments so that you claim under the civil procedure. So what you would do, what I would advise you, is to file in the commercial court of High Court. Actually, now that amount of 60 million does not even go to the Chief Magistrate Court. It goes to the Commercial Court Division of the High Court.
And how long would it take? If I lodge my claim today, how long would I expect it to be heard?
In the commercial court?
Well, in the normal procedure.
In the normal procedure, in the commercial court?
Well, this small claims court.
When it is 60 million?
No, if it's 5 million, let's forget about the 60 million. The normal small claim.
The normal small claim would depend on the number of magistrates at a particular court, the number of cases in that case, in that court, and the speed at which you bring your witnesses in the court. Because you may file a matter and you don't follow it up. You may file a matter and you don't serve the other party. You may file a matter, you serve the other party, but you don't file the affidavit of service. So there are
you don't file the affidavit of service.
When you file a matter against a defender,
yes,
and you serve him with court papers, you must come back to court and file an affidavit of service
confirming that
this other defendant, you
papers.
talk to him those papers and you send them. Yeah, he has to send the summons.
Suppose he says no.
There are also procedures laid down. If somebody does not receive the summons willingly, then there are procedures laid down. And one of them is to swear an affidavit that I went, found Mukasa, he was identified to me by the chief of the area.
He sent his dogs instead.
Oh, he refused to receive service. I'm therefore showing this an affidavit in lieu of service. I left the summons with him, or at his home, or at his door. So you find that affidavit, that document is called an affidavit of service.
If he doesn't sign, you drop it, you slide it under his gate.
No, you don't slide it under his gate.
You come back to court.
You come back to court and sign the
affidavit.
But if you don't find him at his ordinary place of residence,
yes,
you can leave the summons with any adult member of the family.
And they don't have to sign.
They don't have to sign.
They keep them.
But you must identify the person who has received the summons. And you must also, in your affidavit, tell the court that the adult member of the family was identified to me by either the local council member or the chief of that village or an elder of that village, who must have an address as a point of reference.
So you need a referee to go with to that man's gate or whatever.
Normally, there are people we call court process servers. So these court process servers have been taken through the procedure of.
They will be available to you.
Yes, they are available. In this procedure, they are also available, and they will offer free service.
Well, this is Spectrum on Radio 1. You can call in now. Tonight, the Judiciary has taken steps to improve on service delivery and dispute resolution with the small claims procedure. You can call in out, ask questions. Our numbers 0414 348 111, 0312 260 390, 0312 261 390. When you call in, please tell us your name and where you are calling from. Spectrum, hello.
Good evening, everyone.
Good evening, sir. Your name?
My name is Roger.
Yes, Roger. Yes, Roger.
I would like to commend the Judiciary for coming up with such an innovative idea. Now, I just have a simple question. In this case, if one of the parties died, say, I sold a car to somebody, 10 million or 9 million, and he had paid me 6 million, and there was a balance of 4. But one person, like I died, can my wife or children take up the case and recover that balance? Thank you.
Spectrum, hello. Okay, let's hear from you. Spectrum, hello.
Edmond.
Yes, sir. Your name?
Good evening.
Good evening to you.
Yeah, give me the name. Now, a good one. Has there been a formality of putting forms at different locations in the country so that we can reject such claims? Some of us are landlords and we have issues with tenants. But just because maybe we are all tax avoiders, or are we? We might be not tax evaders, my tenant, but I can make some recovery. Good evening.
Interesting question. All right. Spectrum, hello?
Hello?
Yes, ma'am, your name?
Coach Sophie from Clandino.
Come again?
Coach Sophie from Clandino.
Sophie, could you switch off your radio or walk away from it?
I'm appreciative of the alternative social action, and my concern is about parties who intentionally defraud. For example, you take him to court, and after settling that you go and settle everything outside of court, they again turn against you and they don't pay. What could be such a scenario?
Spectrum, hello? Yes, please, your name? Good evening. Yes, Peter.
Thank you so much for coming the magistrate station. It's very informative. I would like to find out, and this is something that has been done very long time, that in that scenario, I'm okay. Going to the smoker court, and okay, is going to pay the money in a certain period of time, and then he fails to pay. The magistrate has saying that profit is going to pay and things like that. But in those cases where someone goes to pay and they earn money and they are going to pay because they are unable to pay, will I get recovered by money, or is the day will have enough for them and when they are done, their time they got free and I lose my money?
All right. All right, that will be answered here. Spectrum, hello?
Hello?
Yes, ma'am. Good evening to you.
My name is Juliet.
Yes, Juliet.
We do debt collection and recovery. Hello?
Yes, Juliet, go on. Female debt collector.
My question to the gentleman is, first of all, I'm very appreciative of that sort of justice, but on the other hand, well, what happens with especially commercial courts? Because most times you find a case there about a debt that is over 10 million or 15 million, it takes a very long time. Is there any system that they're going to put in place for this beyond 10 to 16 million? Thank you.
All right. Spectrum, hello?
Hello.
Yes, please.
Yes, my name is Kabuba.
Yes, Mr. Kakuba.
I appreciate the move to fasten the solution of problems. However, there are 2 points. One is that I have not had, for example, of a place being, of a course being in Mbarara, for example, so that the distance between the one in the Araali and I think Masaka is very big. So what happens to those people? Point number 2, does this facility also assist the person for the recovery of land, for example? Thank you.
All right. Spectrum, hello? 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 Okay, Spectrum, hello? Hello? Yes, your name?
This is John calling from Araali.
Yes, John.
I would like to ask if I had the guest company deducted my him, but we did not make an agreement, but they were witnesses. How could I be here to recover that money?
All right, let's get straight back. So, talk to us, Mr. Araali.
Yeah, I start with John. There is no agreement, but there are witnesses.
Yes.
Now, under this procedure, whether you have an agreement or not, the issue is come and prove your claim. Bring those witnesses on the day appointed for the hearing. And the magistrate will be able to listen to you, the witnesses, and the defendant, and will take a decision there and then. Kakuba is asking about Mbarara, the distance between Kabale and the Masaka, and the population around there, and the area is so wide. I was saying, I had explained earlier, that we are piloting the 6 courts. We don't want to move within the country, and later we fail. We are piloting to see how successful this program can be.
You want the experience of it.
So after the experience of it, we shall keep evaluating and monitoring. Then we shall roll out after detecting challenges, detecting all those issues that will have come out after the implementation exercise.
And there was a female debt collector, Juliet.
There is also this issue of land that can somebody recover under.
Yes.
If it is a debt that I showed you my land and you made with a balance of 5 million, then you recover small claims procedure. Because you are covering a debt, you are not disputing over ownership of land, but you are covering a debt money after selling the land. Right. Yeah. There was commercial court takes a long time to. In other words, she's saying that when they file cases there, they take a long time. The issue of taking long time cases taking long time in courts, we have challenges in the judiciary. For instance, the judiciary, as it is today, has fewer judges. Actually, we have been appealing to the government to recruit the judges. I wish to add that now the process is on. The process is on, but we are saying it should be quickened. For instance, the Supreme Court bench is not fully constituted. The Court of Appeal bench is not fully constituted.
How many people is supposed to have how many does it have now?
The number that is there,
Supreme Court,
is not sufficient.
How many are they supposed to be? How many are they?
Minimum, there should be 7.
Yes,
but they are not 7 now.
How many are they now?
Court of Appeal, they should minimum be 7. They are not there now. So we are saying the appointing authority and those institutions which are supposed to recommend for appointment of judges, they should do their work. And I understand they are doing the work, but let it be quickened because we have insufficient judges. At the commercial court level, still the same problem. But I think when we get the judges, enough judges, people will enjoy the judiciary. That one I can assure you. When it comes to debt collection, the moment the debt is below 10 million, you proceed under small claims procedure. If it is above 10 million, you go to commercial court. Right. Peter, he was saying on enforcement that when we imprison this person for 6 months,
then he comes.
Does the debt end? No, it doesn't. You get that punishment at the same time. You must pay that money.
And if he fails again, he goes back for 6 months.
No. Sophie, who participated for others after saying let's go out of court, then settle. If you have such type of defendant, don't settle out of court. Settle before the magistrate who will enforce his orders. Don't settle out of court. Then there was Jimmy. There are these forms available in the courts. These forms are now available in those 6 designated courts of Mengo, Mbale, Masaka, Lira, Arua, and Kabale. The forms are now there. And in fact, those courts have opened. They started working on 1st November this year. Then Rogers was the first one that if a party died. When I was beginning, I told you that this small claims procedure will not entertain cases to do with estates, because when somebody dies, now it becomes an estate. Right. So it becomes an issue of getting heirs, wills, administrator general to get involved. So that one doesn't fall under the small claims procedure.
And how much is it costing you, this scheme?
As the judiciary,
yes,
we are using the usual operational funds that we have for sensitization. As the public relations department, we have funds as a department to carry out sensitization in form of education to the public, or to tell people what we do as the judiciary. So we are not adding any cost.
You don't need a budget.
So it's a matter of saying that the other day we were talking about bail issues, or things to do with how you can get access to the court. Today we are talking about small claims procedure. So the normal operational funds which are provided to us as a unit in the judiciary for public relations.
So you're not sending people to Masaka, Kabale, and so.
No, the magistrates who were there in those areas are the ones we retrained. We call it retooling. To appreciate this procedure, and they are stationed there. We are not deploying new magistrates, but the magistrates who are there are the ones we retool to give them new techniques about this procedure, so that they can implement the program.
None of them will need a new 4-wheel drive vehicle.
Nothing. We are not buying them vehicles.
Not even
we are only giving them the forms and the posters and the goodwill that they do the work.
Well, very revolutionary it sounds. This is thank you very much indeed, Mr. Araali Muhiirwa, Grade 1 Magistrate, Buganda Road, also Assistant Public Relations Officer of the Judiciary. Thank you very much for coming to Spectrum.
Thanks for hosting me.
It's the kind of thing that you really pray will succeed, because I believe it's going to take away a lot of backlog.
Judiciary has never backed on something and it doesn't succeed. Incidentally, we are on record for that, because we don't go into something without doing research, without carrying out studies, without carrying out comparing notes with our neighboring countries in the region. So we compare notes, look at what other country jurisdictions have done. We see our own situation and say, can this work? So we are not, we usually don't fail when we start on a program. When we started commercial court, we didn't fail. And this one we also not fail. When we started anti-corruption division of High Court, we did not fail. And we see how it works this time.
Alright, we have to go. Thank you very much, Mr. Araali Muhiirwa. Thank you for tuning in. I've been your host, Edmond. So Spectrum will be back tomorrow. Up next is the news in the English language. Thank you very
much. Excuse me, guys. Let me through, please.
Check this guy.